concerned citizens, eminent citizens of the country and all. For me, I think that if a decision of that nature has to be applied, then clearly it must be subjected to the test of the courts in the higher echelons of the judiciary architecture. And I say so because the High Court constitutes the first step in the judicial architecture. Above the High Court are the Court of Appeal and in the Supreme Court. So I think that is not the end of the matter. It should be the soundness or otherwise a decision definitely has to be tested. We have to have a more definitive pronouncement on the merits of the matter by a higher court in the Superior Court of Judicature architecture.
Yeah. I mean, immediately though, the two students, can they show up at Achimota and see to enjoy this, right?
Sure. So that's the result of engagement that I've had today. Today, the Minister for Education gave me a call in the morning. I expressed my view that I think that, yes, an appeal will be proper since it will only lead to either a refinement of this ruling or perhaps a statement of its unsoundness, with all respect, by the Superior Court. So that ought to be done. Secondly, I think that even when the soundness or correctness of the decision is being tested on appeal, there's no justification for a stay of execution to be filed. So it had come to my knowledge that Achimota School had filed a stay of execution. So
they have filed? They said they were filed, so they have actually done it?
Yes.
Okay.
That is a matter of record. So I told the Minister for Education that my view is that the stay of execution should be withdrawn. I had other engagements with the Council for Achimota, as well as the Chairman of the Board of Governors of Achimota, Professor Aite, and my position to them was that, yes, they may pursue their appeal, but I advise that the stay of execution be withdrawn. And they will adhere to that advice or directive. So the stay of execution will be withdrawn. And it will be withdrawn for two simple reasons. I think first and foremost, if there ought not to be any act which will impede or hinder the education of the students in question. The government's policy, the president's main concern is to ensure that all persons who are worthy of secondary education attain same. So the president will be concerned about any action which will prevent a person from going to school. So the students ought to go to school. The school ought to open its doors to them. Secondly, an appeal can be contested without a stay of execution. An appeal can be pursued without the grant of a stay of execution order. Unless it can be shown that the grant of the stay of execution order is so imperative or compelling and that its denial will lead to some injustice and all. In the meantime, any injustice perhaps will just be interim. So I think that the stay of execution be not pursued, that the school can pursue its appeal. The government may even consider, after studying the ruling, whether it will also file an appeal, and will not, in that circumstance, ask for a stay of execution. So the children ought to go to school.
Okay.
The consequence of it is that if we succeed on our appeal, there will only be a reversion to a state school ante. There will only be a reversion to a situation prevailing before.
So the students will have to give up,
have
to withdraw from the school?
Nope, not withdraw from the school.
Okay.
I think it's very important to place on record that the school did not withdraw them, or the school did not say that they had been expelled. The school only insisted on enforcement of its rule and regulation, which required keeping of the hairstyle in a certain manner, or cutting the hair low. I think that's the exact rule, cutting the hair, keeping the hair low. So that is not a denial of admission or education to the students. But because the students found it incompatible with what they perceived to be their religious expression and found it incongruous for them to attend the school when their hair was low, they found it inappropriate, they decided to stay away, as far as I know. The school insisted that yes, the admission is given to you. You could attend the school, but in accordance or in conformity with our rule or regulation, which requires your hair to be kept low. So that's it.
But the effect of that is that they could not enroll, although they've been admitted, they could not enroll in the school.
I think it's just akin to saying you cannot enroll unless you wear a uniform.
True.
Yes, or you cannot enroll unless you bind yourself to wake up at a certain time. It's not correct if you're a boarding student.
Yep.
You cannot be a boarding student unless you stick to regular times at which you either wake up, go to school, dine in, you attend classes and all. You cannot say that, well, even though I'm a boarding student, the practices that were prevailing in my home, whereby my dad would come and wake me at 7:30, will prevail. You may have to wake up at 4:30 in my former school, and then all that. So that is how it is.
Okay, so what, as it is now, for clarity and for the parents who will be listening to you tonight, tomorrow they can take the 2 children to school.
That's my advice. That is my advice. My advice to the school, my advice to the lawyers at Achimota, my advice to the Minister for Education is that the school should open the doors to the students, and the chairman of the board of governors express willingness 100% to comply. I mean, with all respect, I'm the principal legal advisor to the government, and that is my position. It's a public school, and that is my advice to them, and that will be complied with.
So they will go to school still with their dreadlocks on?
In the meantime.
Okay.
And I think that not so much harm will be caused if, say, within 6 months, 9 months, or a year, the Court of Appeal or even the Supreme Court gives a determination, makes a determination in the favor of Achimota School and requiring them to keep their hair low. Nothing will be lost. Then the hair will have to be kept low.
Or they can.
Otherwise, they can be suspended. Yes, they can face the necessary punishment set out the school rules and regulations. If your headmaster says you should do this and you don't do it, what's the consequence? You can be expelled or you can be suspended.
According to the school's rules?
According to the school rules,
which you sign on to when you're
regularly, yes.
I mean, so just for clarity, tomorrow, yes, if you're a parent and your student, go to school.
Yes.
This case will travel its course possibly all the way to the Supreme Court.
Perhaps. Yes.
If you still win, you continue. If you lose, you will either have to remove the dreads or you take the school's punishment. If it's that you can't continue to come there, you face that consequence.
And I expect them to then comply, because to do so means that they are defying the orders of either the Court of Appeal or the Supreme Court. Will it not? It will also imply that they're not law-abiding, and I think that if they are law-abiding, as we all required to do, you ought to respect the decisions emanating from our Supreme Court, which are also part of the laws of Ghana.
So that is the Attorney General there. Well, today, Achimota has filed a stay of execution in an attempt to stop the students from enrolling on the back of their emphatic victory at the High Court. So can they disregard the directive of the Attorney General?
Nope, they cannot, because within the full gamut of law affecting the school is the Pre-Tertiary Education Act. The Pre-Tertiary Education Act constitutes GES as a body with powers to supervise all public schools. GES, the Ghana Education Service, is under the Ministry of Education, is subject to the advice of the Attorney General. All the time we give them advice on various issues. We represent them in court and all. So GES cannot, it will be incongruous for GES to be vested with powers of managing or administering your school. And the principal legal advisor to the government to give advice to the government that and ministry as well as the school that do this, and you will not do it. I think that we perhaps overstretching our imaginations. I think that they will comply.
Explain to the layman who will look at the case itself in court and said, but the school had their own lawyer and you were also represented, and so doesn't that explain the distinction between yourselves and them?
No, because in the scheme of the Pre-Tertiary Education Act, the Board of Governors of every school, high school, has been vested with the duty and function to administer schools in accordance with rules and regulations made by the Ghana Education Service. So they have specific functions given by the Act, and they can be sued, and indeed they were sued. And having been sued, they have the right to represent themselves. They represented themselves, and there's nothing incongruous about that. The Attorney General also cited as a defendant, and the Attorney General was represented. So,
your initial fear was the far-reaching consequences, but based on your advice, can anybody else in any school across the country right now say, well, in the interim, they can go with their dreads? If I also want to go right now, I mean, until the appeal is heard, I can also do so. But currently, there's a pending case of Wesley Girls, where the school says you can't fast.
I think that's a different matter.
Okay, great. but as your fear was that this can open the floodgates. In the interim, you say you can go with your dreads. can also others who may find themselves in a similar situation, cultural expression,
Yes.
etc., also say, well, in the interim, whilst we wait for the Supreme Court to eventually
Right.
can also exercise and enjoy that right?
Well, so the point is that a school properly taking a legal view of the decision of the High Court can say that this is a decision of the High Court. It is not binding on another High Court. Neither is it binding on any of the courts in the the higher echelons of the judicial architecture of state. And for that matter, they are also enforcing their rules and regulations in a certain manner. What will happen is another parent can take the action complained of to the High Court, can challenge the validity of the action complained of at the High Court. And you'll be surprised that another justice of the High Court, or the High Court differently constituted, as the lawyers would say, can give a decision to the contrary. You know about this situation where one justice of the High Court gave a ruling to the effect that demonstrations, if they have to be curtailed by the police, the police can only do so pursuant to an application on notice and never ex parte. That decision has been departed from by many judges of the High Court in different matters. And there has not been anything wrong, because indeed the High Court decision was not binding on another High Court differently constituted. You know about the Face the Country demonstration where an application ex parte was granted by a justice of the High Court and was valid.
In the absence of the court intervention, though, can anybody else try to exercise this right now, getting a judgment and going to a school and say, oh, listen, I also want to enjoy this right?
I think that even when they had no High Court judgment, other schools permitted the...
Yes, in fact, this same child...
Yes, was admitted
they have,
at school.
There's a triplet. Their two sisters are in another senior high school with dreads, and they've been allowed to go.
So really it becomes a matter of enforcement of the rules and regulations. There are schools which entertain burden of mosque on their campuses. There are schools which do not. I think that we have to have a proper, and that's actually one issue that I have with those who support gay rights. They think that it's not progressive for you to advocate against gay rights. I do not understand. I can't come to terms with that. The fact that you find it appropriate to advocate for the rights of gays and lesbians, that's not mean that I should also not have the right to advocate against that practice. And indeed, one of my earlier engagements with some high commissioners here, I made a point to them, high commissioner ambassador, that, well, I should feel free to, our nation should also feel free to advocate against the practice of lesbians and gays. So the fact that your school perhaps not so recognized, entertains a mosque there, does not mean that at the side of it, of course, is more prominent than yours. It's not acting appropriately by not having a mosque there.
Right. But at least you've settled this matter for the parents who were torn on the back of Achimota decision.
And for me, it's a very fair compromise, very fair situation that, yes, you can challenge the correctness of the decision of the High Court because you're a party to the matter and your right to appeal cannot be taken away from you. But in the meantime, let the President's policy to ensure access to education be granted to all. And even indeed the Court for Appeal High Court, Supreme Court, rules in your favor, the effect will still not be a deprivation of the President's policy of free of education, grant of access to education for students of secondary school age. It only means that they have to comply with the school rule by cutting their hair low. Simple as that.
So you had the Attorney General there, Godfred Yeboah-Dame, and the full interview airs tonight at 9 p.m. on the Joe News channel. It's on PM Express. We didn't only talk about this. We talked about Galamsey. We talked about the NDK Financial Services. There's a major case that has just been decided on by the Supreme Court that may save the country in excess of $1 billion cities. We also talked a bit about really did the president give him a free hand to choose his own deputies? You want to hear all that in that interview. For now, though, let's get reactions to what we've just heard there. I want to bring in the lawyer for the students, and I'm pretty sure you've followed this as it unfolded closely. Mr. Wayo joins us on the telephone line right now. Thank you, sir, Mr. Wayo, for your time here on Top Story. Hello, Hello, Mr. Wayo.
Yes, Evans, good evening.
Good evening. Thank you for your time here on Top Story. Just had the Attorney General there. Your reaction?
Thank you very much. I think in the first instance, we need to say thank you to the Almighty Father for how far we have come. And then, by extension, thank the Attorney General and the Minister of Education. And apparently, we know the presidency was involved, as the minister kept talking about. The president would not expect that every child is left behind. So we will thank the powers that be for this amicable resolution, and we think that is the only way to go. The state of execution that was supposed to come would have really taken the matter into a long, protracted side of litigation, but now that is off. But we can hear that the intention to appeal is still there, which we do not disagree, and I think appeal is as of right. So we are grateful for the current resolution, because we have always had this point that it is the paramount interest of the children in respect of their academic studies, and this resolution is seeking to do exactly that. And that means that there is this victory for these children to realize their academic dreams. So we are so grateful, and we'll wait for the content of the appeal if it so comes. If the appeal is also halted, that will bring the matter to a closure. But if it comes, we'll look at what details there is. But for now, we are so grateful for this amicable resolution.
And I asked him very pointedly, can the students go to school tomorrow? And he says, of course they can. It was very categorical. You expect that they will go to school and enroll tomorrow?
Yeah, that is very nice, and that we are so grateful, because any which way we were trying to tell the parent to kickstart the determination that we had on Monday. So we were preparing to go to, I spoke to you on Monday, and my advice was that they should take steps to go to school to give meaning to the ruling or the judgment. And so Wednesday, Thursday, at least, we expected that tomorrow they would be going to school to see the reaction of the Achimota School administration, and then we can advise otherwise. But it's good to hear that before tomorrow, we are hearing this resolution from the Attorney General and the Ministry of Education, and we are so grateful.
And in fact, also I can confirm that Achimota, they did in fact file the stay of execution today, and we can confirm that they have indeed withdrawn that stay of execution, which means that, as the minister indicated, the path is pretty clear now for the two students to go to school. Thankfully, Mr. Wayo, stay with me. Thankfully, joining us also on the telephone line right now is the father of Tyrone Magai. Mr. Magai joins us now. Mr. Magai, thank you for your time here on Top Story.
Yes, I. Thank you.
Yes, so the Attorney General is clear tonight that you can take your son to Achimota School tomorrow. And as we've just been speaking, Achimota has indeed withdrawn their stay of execution, which means they are ready to accept you. Your reaction?
Well, it's a beautiful, thing now that they've done it, because all this while we've been thinking, that what should this be? If the judge has given a verdict, it means, this judge they are also learned people who knows what's actually going on in the country, or knows the laws. So then what was that about, And, we knew in a way that they will maybe have to withdraw it, or I don't know, but it's really nice situation for us now, and we're happy about that.
So when are you finally sending young Tyrone to school?
Okay, we're going to also talk if we're going to take them together with the his brother, with Ohineba in Krabia, his counterpart. Then we will have to talk and see if we're going to do that tomorrow or maybe on Friday because it's not planned, We didn't know we'll have to take them there tomorrow. So we will make the necessary arrangement and then have them go to the school as early as possible.
But you are asserting that at least you take them this week, before the week ends, before Friday you take them.
Yes, sir. That way, it's certainly going to be.
Do you have? Is Tyrone close to you?
Yes, sir. He's close to me.
Okay. Let me have a word with Tyrone. Now, of course, this is just coming on the back of a meeting the Attorney General had with the school authorities today, including the board, the Oak Students Association, the council, the heads of the school. And they were advised, the minister says, were directed to withdraw. They have indeed withdrawn. They were asked to allow Tyrone and his other colleague to enroll, and that is going to happen now. Hello, Tyrone.
Hello, sir.
Yes, Tyrone. So it's now very clear from the Attorney General's position that you can go to school. In fact, Achimota has tonight withdrawn their stay of execution, which was designed to stop you from coming. Which means they are ready to receive you. The minister said you can go to school as soon as tomorrow morning. This must please you greatly.
Yes, please, it is.
How soon are you looking forward to joining your other colleagues who've had a 2 month lead in studies?
Okay. We're looking forward to very soon, hopefully within this week or the following week. But then definitely within this week or the following week.
You can't wait to go, I'm pretty sure.
Yeah, I would say so. I can't really wait to be in Achimota School.
And there's going to be a lot of attention on yourself and your other colleague.
Yes,
have you given a thought to that? How you handle the pressure and anything that comes with it?
Yeah, I've really thought about it, but I'm getting used to it. So I would say I would know how to handle it once I get there at Achimota School.
Tyrone, thank you very much. Your father says he expects that by Friday you'll be in school. You agree with that timeline yourself?
Yes, sir, I do.
You have your Achimota uniforms already?
Yes, please, I do.
Oh, you have your Achimota uniforms already. Have you bought your bag, your books, all the things that you need to purchase for school?
Yes, sir. I have bought everything.
Are you going to be, in boarding house, or are you going to be shuttling between your house and the school?
I'll be a day student.
Tyrone, thank you for talking to us, and all the best as you enroll at Achimota. I still have with me Mr. Wayo, though. So, I mean, the Attorney General was clear, though, that although they can enroll as soon as tomorrow, the appeal will continue because he believes this is a case with far-reaching implications, and he cannot leave it at the level of the High Court. You agree with that?
Yes, I agree with that, and that is where we, as lawyers, have some reservations. You see, the appeal, we hope it doesn't really continue so that the matter ends. But if it continues, even trust me, it is going to be very good so that matters will be put into perspective. If you will recall, the case was fought in two fronts. I mean, Tyrone had my learned friend Gauga standing in, and I and my legal team, Mr. Ishmael Andane, Yahuda Kote, and Julia stood in for Heneba. And some of the arguments that came up when we were moving the application, if you look at the ruling today or the judgment, the judge only concentrated on the violation of the rights, which is the key matter. But some of the submissions we did, for example, from our end is even the rules that have brought us here. And Evans, I heard you question the Attorney General. The rule is that if you have a bushy hair or if you breach that rule, your sanction is internal and external suspension, which presupposes you must be in the school. You must be admitted. But what we are witnessing now is they are denying them admission. But the judge didn't bother to look at all these things. So it's going to be very interesting when we go on the appeal, because when we go on the appeal, which is like a rehearing, the appellate court will look at all the submissions that were made. So when Ghanaians get a ruling that have come, if Ghanaians who understand the law will know that the judge concentrated only on the violations of the right. But I tell Ghanaians, so many other important things were submitted, especially from our end on behalf of Ohineba, even in respect of the rules. Because if you say the punishment for disobeying this bushy head thing is internal and external suspension, then what they are even applying today, which is non-admission, I don't know how to term it, or non-enrollment, does not suffice because it is not in your sanctions. So like you are punishing somebody with a sanction that does not exist. But the judge didn't really talk about all these things. So if we are going on appeal, which we think should not really happen so that this matter ends, but trust me, when we go on appeal, the Achimota's rule will be brought into question because it's the rule that brought us here. And in this judgment, all what the judge said about the rule is that it's not in conformity or it's inconsistent with the Constitution based on the violations. But for example, the Attorney General himself referred to the Pre-Tertiary Act, which is the Education Act 2020, which vests the power to make these school rules only solely with the GES.
Yeah,
so
I mean, and there's a lot of criticism also tonight directed at the GES for not, assuming its responsibilities properly in this matter. But Mr. Wayo, thank you very much. And this is a space you're watching closely. All that remains is for Tyrone and his colleague to simply show up at Achimota. It can be tomorrow, if the father says by close of Friday they will be in school. He says you have the uniforms already. And we'll bring all that to you if that indeed happens. The school has withdrawn their stay on the back of the advice, call it a directive from the Attorney General. The path is clear now, but the appeal will be fought. The Attorney General says he believes it should go all the way to the Supreme Court. We have more on this for you on Newsnight, though. Stay with us.
55, 78, 58, 70. Hey, Charlie. My network is really killing me. I have to pay my uncle's workers via mobile money, but the charges alone, it's about 380 cedis. Hey, charges alone just to send money? That's $10